Mr. Kanyangala, you're still under oath.
Yes, my lord.
Yes, Mr. Kanyangala, we are still dealing with the statement of Mr. Canosa, is that correct?
That's
you
correct.
Recall that? And this is the statement that you also are relying on in these proceedings.
That's correct.
Yes. We have dealt with, if I'm correct, we have dealt with clause 26 just before we took a break. Is that correct?
That's correct.
Yes. If we can go to clause 26.1, is it correct that it talks about agreement between Seaflower Whitefish Corporation and Novanam for utilization of 1,200 metric tons of wet hake quota for the season 2014 and 2015 fishing season?
That's correct.
In that statement, Mr. Canosa says this is a signed agreement dated 18 June 2014.
Yes, that's correct.
He confirms that he signed this agreement on behalf of Novanam, and the witness is Mike Mackenzie.
That's correct.
The Luder is fleet manager, and he recognizes the signature for Seaflower to be that of Mr. Ngepunya.
That's correct.
Once again, he says he cannot specifically remember negotiating the terms of this agreement.
Yes, that
You
is
see
what
that?
he's saying.
So this is the fourth time that he cannot remember anything of importance to the information that was requested by the ACC. You realize that?
Yes, I realize that.
All right. Let's go to paragraph 26.2. He refers to the agreement that was signed between the two companies for 450 metric tons. Is that correct?
That's correct.
And this was a signed quota agreement dated 22nd July 2014.
That's correct.
He says this agreement was signed on behalf of Novanam by Mackenzie, the fleet manager.
That's correct.
Once again, for the fifth time, he says he does not specifically recall having negotiated the terms of this agreement, but it is likely that he negotiated it with Seaflower.
That's correct.
What did you make of this pattern thus far, when you were accepting this statement and relying on it?
I do not make out anything.
Excuse me?
I do not make out anything.
Why not?
Because this is the way he wants to put his statement.
Yeah, but the statement itself, in so many respects, he keep on saying...
I cannot
let
force
me
a person
yeah.
to give the statement
Let me finish.
apart from what he wants it to be.
Let me finish. Once again, he confirms repeatedly that he cannot remember the specific details of something that he said he was the chief negotiator.
Yes.
What was the difference between this gentleman and Luis Fernandez? Why did you go to Luis Fernandez and seek additional information and clarity, and yet you did not do the same thing for this witness?
Luis Fernandez.
We spoke about Luis Fernandez before
Yes.
I gave you the email where you yourself sent the email requesting clarity on certain aspects. And yet, to Mr. Canosa, nothing like that occurred.
Yes, that's why I say I was satisfied with what he provided.
Despite him constantly saying that he forgot the very essence of what you requested from him.
Yes, because that is what he wants to say in his statement.
All right. Let's continue. The agreement 26.3, he refers to another agreement.
That's correct.
He tells you when this agreement was signed and for how much metric tonnage was this agreement.
That's correct.
Once again, he says he does not specifically recall having negotiated the terms of this agreement, but it is likely that he negotiated with Seaflower. Do you see the pattern?
Yes, I see.
There is a lot that this man does not recall.
Yes.
That is important. Does he have a memory problem?
That's
why I was asking you in the beginning whether he has a memory problem.
Behavior. Therefore, I cannot say he's having a memory problem.
You said you spoke to him. When you spoke with him, did he seem to recall some of this important information here?
He spoke just like he put it in his statement.
And you were satisfied with that?
That's correct.
Wow. Let's go to 26.4. The next page, page 5. He was referring to the agreement which he concluded on 27th of August 2015. You see that?
Yes.
Relating to Exhibit Z20, which is already before the court.
Yes.
He mentions that the agreement was signed by the CEO on behalf of Novanam. Once again, he does not specifically recall having negotiated the terms of this agreement, but it is likely that he did.
Yes.
He goes on for the next paragraph. The same thing.
Yes.
In respect of the agreement of 4 September 2015. He then goes, he says he does not specifically recall having negotiated this agreement, but it is likely that he did, and I'm talking about 26.6.
Yes.
And you are relying on this statement
Yes, I'm relying on it.
to prove the guilt of our client and to oppose this bail.
That's correct.
Your standards must be very low.
You can take it like that.
All right. He also says, paragraph 26.7, he refers to an agreement that was signed for 110 tons of Hague for the quota of 2016, you see that? And
Yes.
1,000 metric tons of wet Hague for the same time as well, of 2016, is that correct?
That's correct.
He says this agreement was signed and is dated 18 July 2016.
That's correct.
He says the only thing that he noted was clause 3 of the agreement, which he did not negotiate with Seaflower.
Yes, that is what he said.
But based on what he had said before, that whenever the agreement was sent to him, he would recommend such an agreement to his superiors. It's fair to conclude that he still recommended it, for approval to his bosses, if one has regard to paragraph 22, 23, and 24 of the same affidavit.
That is what he put in his statement.
Yes. He then goes on to paragraph 26.8 for the 2,000 metric tons of Hague freezer quota for the 2016-2017 season. You see that?
Yes, I'm seeing.
He confirms that he signed this agreement on 22 December 2016.
That's correct.
He recognizes the signature of my client, and he signed on behalf of Novanam.
That's correct.
Once again, he does not specifically recall having negotiated this agreement, but it is most likely that he may have. And he still accepted this explanation.
That's correct.
He then went on to talk about clause 26.9, where he deals with an agreement for 1,000 metric tons of Hague freezer quota for 2016-2017.
That's correct.
And once again, he says it was dated 14 August 2017.
That's correct.
The agreement was signed by Mr. Edwin Kamatoto on behalf of Novanam, and he recognizes the signature of that of Mr. Ngepunya.
That's correct.
Once again, he does not recall having negotiated the terms of this agreement, but it is most probably that he did.
That's correct.
Do you seriously think that this court should rely on a witness that has a self-confessed problem with memory? Such
This
as
is
Mr.
how
Kaman.
he decided to put his statement. And
Yes,
I
but
cannot
I'm
force
asking
him
you.
to change his statement.
You have brought this statement before court, you are relying on it.
Yes.
Do you seriously and
That is
genuinely
not my
expect,
statement.
listen to me, do you seriously and genuinely expect the court to rely on the credibility of this witness?
Yes, I did.
All right. Let's go to the next paragraph, 26.10. You see paragraph 26.10?
Yes, I'm seeing it.
It deals with 3,000 metric tons for the quota for the 2017-2018 season. That was dated 18 December 2017. Is that correct?
That's correct.
He then says, once again, he does not specifically recall having negotiated the terms of this agreement, but it is most likely that he did.
That's correct.
And once again, I say this man seems to have a serious problem with memory.
You can make your own conclusion.
Yes, and it's very strange that you are relying on him. I put it to you that you should not rely, on a statement of this nature to seek to oppose the bail of our clients in this matter.
I will rely on it.
Right. He goes on in paragraph 26.11. He deals with another 1,000 metric tons for 7 August 2018. And guess what? He still does not specifically recall having negotiated the terms of this agreement, but it is most likely that he did.
Yes.
And the ACC accepted this explanation despite having requested him to explain the circumstances surrounding the negotiations of all these agreements.
Yes.
And you thought that was sufficient for your work for purposes of giving our clients a fair hearing before this court? Based on somebody...
Sufficient.
All right. Let's continue. He goes to 26.12, where he says he signed this agreement as a witness to the signature of Mr. Edwin Kamatoto. And he recognizes the signature of my client.
That's correct.
Once again, he does not specifically recall having negotiated the terms of this agreement, but it is most likely that he did.
That's correct.
And you still thought that these explanations were sound for purposes of being relied upon in this court?
That's correct.
All right. He then goes to the clause 26.13. You see that?
Yes, I'm seeing.
How much quota was that agreement for?
It's 1,000 quotas.
And what was the date of that agreement?
It's 9 May 2019.
Can you read the last paragraph of that clause 26.13?
He said, I may have negotiated the terms of this agreement with Sea Flower, although I cannot specifically remember having done so.
Yes. Can I take you to clause 26.15?
Yes.
Can you confirm to the court that after setting out the name of the agreement there and the tonnage, metric tonnage that was allocated for that or agreed for that fishing season, he also still does not specifically remember negotiating his terms, but it is likely that he did?
That's correct.
Paragraph 26.16, at least he states there that the agreement or the terms of the agreement are familiar to him, especially the price, but he did not negotiate the terms of this agreement.
That's correct.
All right. Let's go to Part D of that statement. You see that Part D?
Yes, I'm following.
You see that he says the arrangement with Sea Flower had been that the entity holding the quota sold to us by Sea Flower would render its invoice to Novanam for payment of the quota price.
That's correct.
Would that explain why the Namibia Fish Consumption Trust and Nam Coast Fisheries directly send the invoices to this Novanam for the quota that was allocated for that year?
That's correct.
In their invoices, they never said that they are invoicing him for management fees and consultancy fees.
That's correct.
In fact, the whole quota of that year was payable and paid in accordance with the invoices of those two entities. Is that correct?
That's correct.
He then goes on 28. Sometime after we had been conducting business with Sea Flower, the exact date which he cannot recall. Is that correct?
That's correct.
So he did not provide you of the month nor the year in which these negotiations happened,
That's correct.
because he cannot recall all that. But he says Mr. Ngepunya discussed with him a change in the payment of arrangements of the negotiated price.
That's correct.
Is that correct?
Yes.
What is a discussion, according to your understanding?
It's a conversation between two people.
So there was just a conversation between the two of them.
He mentioned Mike.
Yes, that's what I'm trying to, I'm trying to establish.
He's the only one that was mentioned.
All right. He then says, so basically he doesn't say he was given a directive by Mike or an order by Mike or a change of the agreement by Mike. Is that correct?
That's correct.
There was just a conversation between the two of them. Is that so?
Is it a conversation or a discussion? Because he says Ngepunya discussed with me. So it's not just a conversation, it's a discussion of a change of payment method.
Yes, my lord, we went to the word conversation after I asked the witness what he appreciates of the discussion, and he said it's a conversation.
It is interpretation.
Yes. So I'm
yeah, but I'm
Correct.
just trying to put what is here. Here is discuss.
Yes,
so
my
what
lord.
how he interprets it is
All right.
Yeah.
That is in order, my lord. We have already written what is in there.
Yeah.
No problem, my lord.
So I'm sorry to have interrupted you.
No, my lord, actually it's quite good. I appreciate, because all I want is for his lordship to get the information and the conversation. And if you are paying attention, I couldn't be more happier, my lord.
All right.
If we go to paragraph 29, you see that paragraph 29.
Yes, I see the paragraph.
He says, Mr. Ngepunya told me that there would be a new payment arrangement as follows. He would provide us with 2 invoices for the quota.
Yes.
I understood. You get all that Mike said. He would provide us with 2 invoices for the quota. Is that correct?
Yes.
But he seems to have understood without actually giving any further information when one has looked, to this statement. He says, I understood that Seaflower would issue an invoice and another company would issue a second invoice. The combined total of the invoices would be equal in value of the quota price we agreed on. Don't you find that strange? Because he is not saying this is what Mike says.
That is a statement.
That is his own interpretation. He is told that there will be 2 invoices that are issued to you. He then makes his own interpretation that is not backed up by what he was told.
I don't know what he was told.
Yes, but he has told you here. I mean, we are looking at the statement, you and I. This is the statement that you are relying on. He also has not said on whose behalf Mike was discussing this with him.
That's
and
correct.
who Mike was representing when he was, having these discussions.
Yes, he did
Is that
not
correct?
indicate so.
I beg your pardon?
I say he did not indicate it so.
Oh, thank you. He then says, these invoices included invoices he received as issued from Monakadu, Investment, Kwanyamba Investment Trust, and Fine Seafood Investment Trust. But this is not what Mike told him.
I don't know what he told him.
Yes, you know because he has told you, so you cannot say you don't know. You can read, can't you? You can read paragraph 29, what he was told.
Yes, he did not
Yes.
indicate it in his statement.
Exactly. So Mr. Ngepunya referred to the payments to the third parties, entities, as management fees, facilitation fees, and consultation fees. We did not discuss the rendering of any specific services by the third party entities. Is that correct? That's what he says there.
That is what he's saying.
He says after this conversation, it became the method on which Seaflower negotiated with the price of the quota. It was also the method Seaflower would invoice Novanam for the quota. He informed the Novanam management, being the CEO and the financial manager, of the system of payment when he received these invoices.
That's correct.
When he filed this statement, he told you that he had already been aware that his boss, Mr. Kamatoto, had filed another, 2 affidavits. Is that correct, to the ACC?
I don't know whether it is his boss.
Yes, but Mr. Kamatoto, who is the MD, this guy is
Yes,
just the manager of fleet services.
Yes, he indicated so.
Did you read the statement of Mr. Kamatoto in comparison to what this gentleman is saying here to try to make sense of this statement?
No, I did not compare the statements.
All right. I wish you had, because what Mr. Kamatoto says in there, because this gentleman has a propensity to tell people or to say he did some things so certain people were aware, and his own MD of the company, Mr. Kamatoto, I have his statement here, my lord. I don't know whether it was already an exhibit. Let me just find out from my learned friend.
Kamatoto, that I can recall, it wasn't. It was never admitted as an exhibit.
All right, my lord, we did not provide the copies, but I can engage the witness further on. We will only come back to it if it's necessary to do so. He then says that the third-party entities did not render any services to Novanam as described in the invoices as maintenance fees. Is that correct? That's what he says.
That's correct.
My instructions are that these services were rendered, and he was aware that those services were rendered. In fact, there is no invoice from a third party that is claiming to be an invoice for a quota. All the invoices were for consultancy services that were provided. Those are my instructions. Any comment?
I will comment that If there was any services rendered, the applicant, when we requested them to provide proof of what they have rendered, they could give us to us, and they never did.
And when did you request this proof? Was it after they were arrested?
It was not after they were arrested.
Right, it was prior to the arrest.
Some prior to the arrest, yes.
I'll ask you, and this is very important, because you say they were asked to explain. Did you ask my client to explain at any moment?
No. He didn't say they were asked to explain.
All right.
They were asked to prove
Yes.
the services that they rendered.
All right.
Yeah.
All right.
He didn't say they were asked to explain.
Yes.
They were asked to prove.
All right.
Yeah.
Was my client part of those people that were asked to prove anything relating to this statement?
I asked the owner of Njako
Yes.
Investment Trust.
Yes. Can you hear my question and answer my
Yes.
question? Yes. Did you ask Mr. Ngepunya to
I
prove
did
this
not
service?
ask him,
All right.
but he was requested to come and give a statement. To be
Are you
questioned on
referring
those-
to Mr. Ngipunya now?
Yes.
Okay.
All right. Yes, please continue because this is interesting.
I said, yesterday, you told me he was contacted that he must go to Oshakati office to go and give a statement. On his way back to Windhoek, he called, but he never make any arrangement with that person who was supposed to obtain a statement from him to come and give a statement.
All right. We have already gone through this yesterday where I put it to you, unless if you want to change your version now. I put it to you that Mr. Ngepunya was called while he was in the north. He was specifically advised to go to a regional office of the ACC in Oshakati to give a statement. But the ACC official would arrange the time when such would be made. And no such time was communicated to Mr. Ngepunya.
That's correct?
Yes, that's correct.
Yes.
Okay, thank you. So, on that basis, you can't say that he did not give the statement because he was told that arrangements would be made for him to give that statement in the north.
Yes, he did not give a statement,
Thank you. So,
but there was a chance for him to give a statement.
that chance was never availed because the time it was dependent on the time being availed to him to go. The time and the date would be availed by the investigating officer.
But the time when he was charged, he could still give his explanation on the allegation.
It's a whole different ball game once you are charged.
Yes.
And when you provide
Don't
the
debate,
statement.
Mr. Patela, don't debate.
All right,
Ask
my lord.
question, let's go on.
Yes, please, my lord. This gentleman in paragraph 36, you see paragraph 36,
Yes, I've seen.
he mentions that upon receipt of invoices, he did not scrutinize their content. Did you read this sentence?
Yes, I read it.
And in your usual way, you are satisfied with it, I assume.
That is what you want to put in.
Did
his
you
statement.
check any other documents that you have or you had in your docket to confirm this, that he did not scrutinize those those invoices
Any other document like?
that are in your docket? Did you look at any other information that was in your docket to scrutinize whether he was correct in what he's saying here?
I did not compare that paragraph with what is in the docket.
All right. If you find that he actually scrutinized these invoices, what would you tell the court?
If I find that he scrutinized,
Yes, if I point you to information to the effect that he actually scrutinized these documents, what would you tell the court about this witness?
if there is any such of proof, I can tell what is standing as per that proof.
Can I refer His Lordship to Z21, Roman letter 7, my lord?
Z?
21, Roman letter 7. His Lordship will also have regard to Z21, Roman letter 43. I believe they will be on page
Roman letter?
Roman letter 43. The documents, my lord, in the state bundle. They will appear from page 178 of that bundle.
That's the invoices of Wanakadu.
No, he's not talking about Wanakatu, he's talking about invoices generally from these alleged third parties.
Yeah, that's what I'm
It
saying.
would also include Wanakatu, my lord.
Yeah, my Z21, Roman 4, is the invoice of Wanakadu dated 6 June 2017. Z25 is an invoice of 21 August 2017. Z21 Roman 6, it's an invoice of 21 December.
My lord, may I, with the greatest respect, try to assist?
Okay.
If you look at Z21, Roman letter 43.
Roman letter?
43.
Okay.
It's also titled JR162. It's on page 178 of the state's bundle.
170?
178, handwritten at the top right.
Yes.
Are you looking at it, my lord?
Yes.
All right.
That's an invoice from... No, it's an email.
Yes, it's an email that Mr. Kanoza sent to Wayamba Investment Trust.
Yes.
Yes. Can you look at it, Mr. Kayangela?
Yes.
What does it say in that email?
It says, can you put tax invoice, please? The other two is already in process. I know you fly tomorrow. See if you can modify before you fly.
Yes. What would it be that he's modificating? Would that be an invoice?
That's correct.
All right. Let's go to the next page, 179. Do you see that email?
Yes, I see the email.
It's from the same Mr. Jose Ramon Canosa, is that correct?
That's correct.
To Wayamba Investment Trust.
That's correct.
Last invoice is for beneficiation of fees 2018-2019, is that correct?
That's correct.
He says, hi, Mike. At today, all the invoices of GIT are already paid. You can see in the POP that I already sent to you. For end of month, well, he's not an English speaker, native English speaker, but he'll say we'll pay the full amount of fine seafood. But I still need you to correct the invoice. Is that correct?
That's correct.
Where they put invoice, please, they must put tax invoice and will be fined for process. Is that correct?
That's correct.
Reading these emails today, does this appear like an email from somebody that did not scrutinize the invoice at any time?
It looks that he scrutinized the invoices.
Thank you. And you will understand why I say this witness has a serious credibility problem. First of all, he is not truthful. Number two, also he has a serious memory problem.
That's why I say you can make a conclusion on that one.
Yes, but I want to hear your comment.
Oh, I cannot make a conclusion.
Yes, that's why I'm saying you did a poor job of assessing this statement that you want the court to use to deny my client bail in this application.
That is how the person wants to put his statement.
All right.
I cannot force him to change that version. Okay.
All right. He also in Part D, from paragraph 38, has a series of invoices, you see that?
That's correct.
That he's talking about there.
That's correct.
When you look at these invoices alone, they are more than the two invoices that they said he had previously said they will be issued. One invoice for, one company and one invoice for one company for each fishing season or for the quota. Is that correct? When you just look at them, this would constitute quite a lot of invoices for the quota that was allocated. I will argue this, but I'm just giving you an opportunity.
I understand the question.
Yes. Previously, my lord, in one of the paragraphs, when he was talking about the arrangement, the alleged arrangement, which...
Paragraph 29?
That will be paragraph 29. He says that there will be 2 invoices provided for the quota. Is that correct?
That's correct.
And to the extent, and I'm not saying these invoices are for the quota, because my instructions are that these invoices had nothing to do with the quota. But even if his version was correct, even if that was not disputed, the invoices that are sent per quota are simply too numerous to support that arrangement that he spoke about.
How I understand such statement is that 2 invoices have to be issued. One from Seaflower Whitefish and another from a different company, from a different entity. That is how I understand it.
And be that as it may, when you look at these invoices per quota that was allocated, because he has given a series of all those agreements, when you benchmark those agreements to these invoices, they are simply too numerous to support that arrangement that he spoke about earlier in paragraph 29.
On what basis is that proposition being put to this witness?
Yes, we are just...
No, I'm asking. You see, why I'm asking is, a quota is, for example, 3,000 metric tons at $4,000 per ton. That can give you 12 million. I can invoice 12 separate invoices, and it's for that quota.
Yes.
I can invoice one invoice for 12 million, it's for one quota. I can invoice 12 of them at 1 million, 1 million. So that proposition must have a basis on which it's being put to the witness.
Yes. Okay, my lord, if there was one invoice provided for that quota, because he says there will be 2 invoices for the quota.
Yes.
You know, not for part of the quota.
No, it's 2 invoices for the quota.
Yes, my lord.
Yeah.
So assuming the quota is 1,000, there will be a quota, an invoice for 1,000, and an invoice for
Remember, it's
something
the
else.
amount that is invoiced.
Yes, my lord.
So what matters is I'm not saying you are wrong. All that I'm saying, put the basis on which you are saying there is more than one invoice in respect of a quota.
Yes.
What is the basis for that proposition to the witness?
Yes.
That's all I want you to
All right.
say. Yeah. I can't debate with you and say you are correct or you are wrong. All that I'm asking is give us the basis on which that proposition is being made for the witness.
All right. That is fine, my lord. In fact, that's where I'm moving to those details. But I wanted to look at the agreement and then, yes. But before I get there, let me just finish at least with the statement. Then we can interrogate the supporting information, my lord.
All right.
He also spoke in paragraph 47. You remember there was paragraph 47 that you referred to in your testimony in chief.
That's correct.
In fact, this part was not put to my client during his testimony under cross-examination. You will recall that when this issue was, raised, the court gave us the opportunity that should it be necessary in future, after you have testified, we can always recall Mr. Ngepunya to deal with this aspect of paragraph 47. You remember that?
Yes, I can still remember.
Yes. But let's look at it nonetheless. We will then apply our mind in terms of what to do going forward. We can, make what we make of this statement of Mr. Kanoza that I say, already has a serious credibility issues. He says it came to his knowledge that Mr. Ngepunya was arrested during February 2020 and has remained in detention since then. Is that correct? That's what
correct.
he says. He says he was conducted on his mobile phone on at least 2 occasions. Is that correct?
That's correct.
He has not given us the actual mobile phone number that he was contacted on. Is that correct?
That's correct.
He also has not told...
No, it's not correct. He has contacted me on my mobile phone at least 2 occasions from prison, an undisclosed number.
Yes, but...
From an undisclosed telephone number.
We agree together. We are together, my lord.
Yeah.
But I'm saying...
And he explains it's displaying no number on my mobile's screen.
Yes, my lord.
So I just want you to put, when you are putting, let it be on the factual issues that a person has testified to.
All right, that is correct, my lord.
Yeah.
But when I say he, I mean Mr. Canosa's own mobile number, we don't have it.
Oh, okay.
Yes.
Oh, then, yeah, that's now clarity of language. That
It's fine, my lord. It's only the course of the a day's work, my lord.
Yeah.
It's fine. Mr. Canosa has not given us his mobile phone number. Is that correct?
That's correct.
He has also not provided us, at least in this discovery, in these proceedings, he has not provided the court with his phone records. Is that correct?
That's correct.
There is no indication and there is no way that the court and us in these proceedings, we can verify the correctness of this because there is no supporting information. Is that correct?
That's correct. Apart from his statement.
He also has not provided when exactly these calls were made. Is that correct?
That's correct.
He has also not provided the time when these calls were made.
That's correct.
And you will understand when I argue that the statement there is so vague that it's surprising that an investigating officer of your
You
caliber
can take it like that.
would want to rely on a statement such as that is so unclear and so lacking of details to provide sufficient guidance to the court.
What was important to me is that he gave a statement under oath where he confirmed that, yes, indeed he was contacted while the person was in,
Yes,
in detention.
my instructions are that these phone calls never happened.
That is your instructions
All right.
that were given.
He then goes ahead in paragraph 49, although he goes back to 48.1, but be that as it may, paragraph 49, he says he was requested to sign the agreement between Skeleton Coast Trolling and Wanyamba Investment Trust. Is that correct?
That's correct.
In this conversation, he doesn't say that he was requested to avail a bogus passport. Is that correct? In the discussions with Mr. Ngepunya, supposing they happened, would that be correct that the statement doesn't say so?
A bogus passport.
Yes. A falsified passport.
No, he did not.
He
mention.
also does not say Mr. Ngepunya asked him to make arrangements for him to escape from detention. Is that correct?
That's correct.
He also doesn't say Mr. Ngepunya sought the assistance for him to escape the jurisdiction of this court.
That's correct.
All he says, and assuming it was done, is that Mr. Ngepunya wanted financial assistance to fight this battle in court. Is that correct?
I did not indicate such in the statement.
He says he was contracted for financial assistance in paragraph 48.2. Would that be correct?
Yes, he did so.
All right.
I also just want to follow the cross-examination. Perhaps can you just indicate where he says he wants to fight in court? Mr. Ngepunya wants to fight his battle in court. I just want that so I can follow as well, Your Lordship.
it's a fair request.
No, my lord, it's absolutely fair, but I was just putting a contention with the witness. If he objects, he can object, but I don't understand the objection at this stage.
Yes, what I heard is that the witness says A, B, C, D, that Mr. Ngepunya is requesting for funds to fight his battle in court. So I just want to know where is that in the statement?
All right. My lord, the objection is fair. I will rephrase. Yes. But perhaps before I do that, I remember, my lord, when this portion of the statement was sought to be read and introduced, we raised an objection because we said it may have issues of attorney and client confidentiality. So let me perhaps try to take instructions before I respond, and then we can determine our way forward, because we still have that objection that is standing.
On that objection, Your Lordship, we already received a ruling that there is nothing confidential regarding what is said in the statement. There is no outstanding objection.
My lord, we have our general objection, but I understand, I don't recall actually whether it was provisionally read or we received a ruling from the court that was. All I remember is that when these issues were dealt with at that stage, the court said, should it be necessary, Mr. Ngipunya will be afforded the opportunity to come back in the witness stand and only deal with that aspect pertaining to paragraph 47.
I wish I had an elephant's memory to be able to remember exactly every detail of what I did. I also can't remember whether I made a ruling or not.
Yes.
I must be frank.
Yes. Unfortunately,
but I can't remember upholding an objection on the basis that it is privilege, attorney and client privilege. That I can't remember.
My Lord, it would help me if you can't remember, you can make a ruling because it will advise what I do then from now on.
You want me to make a ruling now?
Your Lordship, I recall clearly that the court in fact already ruled on this issue. We'll just look for the page number and refer the court to it because there was no privileged communication between Mr. Engelbrecht and his client based on what he said in the statement. Because this was a request for funds. It was communication between the two, Mr. Ngipunya and the witness. So the court ruled that there was no privilege between the parties, but we'll just look for it in the record and refer the court to it.
Unfortunately, I have trust issues, my Lord, as you may well appreciate. I hear what my learned friend says.
Mr. Patela, you're also facing one small dilemma.
Yes, it pleases you, my Lord.
You have chosen to cross-examine on this document. So you can't pick what you want out of the document and what you don't want.
I can pick, his Lordship can direct me otherwise. But
yeah, no, I'm directing you now. That, you see, you have chosen and elected to cross-examine on the document.
Yes, my Lord.
So you can't choose now that, okay, this suits me, this doesn't suit me, I don't want this, I want this.
Actually, my Lord, if
that's a dilemma you are facing.
Yes. Now. My Lord, I always have plan B. So
yeah.
That's why I was saying if I get clarity that there was a ruling, I have no problem, my Lord, in continuing.
No, apart from the ruling, yes. Now I'm telling you that you have elected to cross-examine on this document. Lord. Through and through, so you can now come and choose and pick that this is privilege and this is not privilege.
Should I accept that that is the ruling of the court? That
for now, what I'm saying to you,
yes,
you have chosen and elected to cross-examine.
I have to live with it.
You have to live with it.
All right, let me live with it, my Lord. Yeah. If we go to the paragraph just above paragraph 50, you see that. It's unnumbered.
The paragraph.
Yeah, it starts with, I received Mr. Engelbrecht banking details through a WhatsApp message. As far as he can recall from a person he knew as OT who told him that he is one of Mr. Ngipunya's friends.
Yes.
He says he instructed his gardener to make a cash deposit into Mr. Engelbrecht account of an amount in the range, and this is quite strange, in the range of 30 to 50,000. You see that statement?
Yes, I see.
He does not tell from whose funds this gardener was instructed to make this cash deposit.
He does. The money I paid was my own funds, which I kept home.
All right, we will deal with that, my Lord, but I'm saying at least in that sentence.
Okay.
Yes, because I'm impeaching the entire paragraph. I'm just saying, at least in so far as that sentence is concerned. Is that correct, Mr.?
That's correct.
He also does not give an exact amount that he paid.
He did not give the exact amount?
Yes, because he said he gave instructions. He instructed the gardener to make a cash deposit into Mr. Engelbrecht account of an amount in the range of 30,000 to 50,000. Shouldn't a normal person recall the exact amount that he paid? I mean, that's a lot of money. 30,000 to 50,000 is a lot of money.
Yeah, it depends as to how he wants to handle his money.
All right. Once again, he says he cannot recall the exact amount.
Yes.
My apologies to interrupt. Just to indicate that page 562 of the record, the court's ruling is in fact there, where the court ruled.
To the record.
As it plays the court, Your Lordship.
Page
562.
Yeah.
It's in the second paragraph where it's indicated court. And he says, yes, my ruling is that the statement put to Mr. Ngipunya here does not border on, it says border, yes, on attorney-client privilege. He has the choice to answer it. I will, as a court, I can never compel a witness to answer or not to answer the question, but I can tell a witness, you do not answer that question. So the court had ruled on it that it's not privileged information, Your Lordship.
Noted, my Lord, in view of the dilemma that His Lordship had already observed with me, I'm thankful to my learned friend for clarifying that, but we are already halfway through the statement, my Lord.
Right.
Yes. He also, we had just, you had just answered that this gentleman does not tell the court or does not inform, at least in this affidavit, how much exactly he paid, because he also says he cannot recall the exact amount. Is that correct?
That's correct.
Surprisingly, he also says he did not keep the deposit slip. Is that correct?
Yes, that is what he's saying.
He has not provided the ACC with any other information regarding this payment except the mere say so in this paragraph.
Yes, he did not provide it.
He does not even know the exact amount that he paid, judging by this statement. Is that correct?
He only gave the range.
Yes. I've already told you that my instructions are that there was never any phone call by my client to this witness, and this witness is not telling the truth.
I will disagree with that one, because the payment that he's referred to, it was made.
Yes. But only you know that it was made. Would that be correct?
Mr. Engelbrecht also no.
That's where we tread on dangerous grounds.
Yes.
When we want Mr. Engelbrecht to come and testify.
Yes, it's mischievous, my Lord.
Yeah.
He read the statement.
It's not mischief. Let's not attribute everything to mischief. It may be, he's a layman. He doesn't know, most likely, I wouldn't attribute it to mischief.
All right, my Lord.
Yeah.
But there is method to these actions that I can say, my Lord. But be that as it may, in this statement that you have provided to us here, you have no other information, no copies of deposit slip, nothing whatsoever.
That's correct.
Yes. So, as who I am litigating here on this matter, and the court is not able to check whether these deposits were made because you decided not to obtain that information from Mr. Canosa.
The information is on the bank statement.
Yes, but Mr. Canosa has not provided that bank statement, has he?
He did not.
Thank you. Yeah. Which one? Yeah, no, we can go through them. Yes. Before the adjournment, before we went for lunch, we went through a couple of agreements. Lord, I don't remember whether page 104, let me just confirm my learned friend.
104?
Page 104 of the State's Discovery bundle, the agreement of Novanam and Sea Flower Whitefish Corporation. Was it 23?
104, no, yeah, AK 95.
Yes, my Lord, I wanted to just confirm that it's still not an exhibit. Such that
Still
if
not
it
an
is-
exhibit.
Yes.
Yeah.
May it be admitted as an exhibit, my Lord?
That will be now DD. Exhibit DD.
Before we move to exhibit DD, Mr. Kajengela, I'm informing you and I'm giving you the chance to comment that I'm going to argue at the close of these proceedings, when I make my final submissions, that the court, in the assessment of the strength of your case, cannot place reliance and should not place reliance on this statement of Mr. Jose Ramon Canosa Camano, because it has demonstrated such unreliability in terms of credibility, in terms of clear recollection, as well as the information that was provided. While it may be acceptable to you at the ACC, it clearly should not be placed with any weight before this honorable court. Do you have any comment?
You can make your submission to the court. Then the court can make a ruling on such a statement.
All right. On this statement alone, did you count how many times? Because you also had statement during lunch, I assume. Did you count how many times Mr. Canosa in this statement alone says that he does not remember or recall something?
I do not count.
All right. Can we do that? Because I want to...
Yes, you can do that.
Yes. Paragraph 15 is one.
Just hold on. Paragraph 15.
Yes.
Yes.
Paragraph 15, paragraph 20. You see that?
Yes.
Paragraph 26. Paragraph 26.1.
Paragraph.
Are you with me? Should I continue?
At which paragraph are you now?
I said paragraph 26 is 3.
Yes.
Paragraph 26.1 is 4. Paragraph 26.2 is 5. Paragraph 26.3 would be 6. Are you still with me?
Yes, I'm still with
Let's turn the page to page 5. Paragraph 26.4.
Yes.
Paragraph 26.5.
Yes.
Paragraph 26.6.
Yes.
Paragraph 26.8. Paragraph 26.9. Paragraph 26.10. Paragraph 26.11. Paragraph 26.12. Paragraph 26.13. Paragraph 26.14. No, not 14. Paragraph 26.15, sorry. That is in respect of the agreements only, is that correct?
Yes, correct.
Paragraph 28.
Yes.
Paragraph 48.2, the second paragraph. Yes, the last page. The third paragraph, you see it at the bottom.
Yes.
So this would be how many times, according to your calculation? Let me say if you 18 times.
Yes, correct.
You correct that it was 18 times. All right. Can we go to page 108, my lord, of that bundle? For example, Exhibit 21 on page 108, do you see that?
Yes.
Let me just clarify. This is an invoice, as you can see it, from Wanakatu Investment to an entity called Deep Ocean Processors. Is that correct?
That's correct.
This will be one of the subsidiaries of Novanam. Is that correct?
That's correct.
This invoice is very clear what it was issued for. Is that correct?
To me, it is not clear.
Yeah, to you, but I'm saying what is written in there is clear.
Yeah, it's clear what is written there.
It describes the services that what the fees were for. Is that correct?
That's correct.
These were consulting fees for the first 6 months of June of 2017 between January and June. Is that correct?
That's correct.
The unit number also is stated therein and the total amount.
That's correct.
This invoice does not specify or say that it was for fishing quota. Is that correct?
That's correct.
And I put it to you that Mr. Canosa, we had concluded the agreements that we have already looked at in the 2 previous agreements of Novanam, and fully aware of the rise of Novanam, he could not have misunderstood what the services that were charged here were for, if they were for anything relating to the quota, because the invoice does not say that it was for the quota.
This was just the second invoices that was issued for the quotas.
So this is, according to you, part
These
of the
companies did not enter into any agreement with Novanam with regarding to quotas.
This is part of the bigger scheme that only you can see, but which we don't see when we look at the papers ourselves.
I don't know why we can not see that.
Yes, because the invoice is very clear of the services that were given. I mean, it's written, we can read. I'm just giving you the opportunity to comment. The invoice
I
does
can
not say
read
that,
what is written there.
yes, the invoice does not say that it was for the fishing quota.
Yes, and the statement of the witnesses also indicating that although such services is indicated, it was never rendered.
There's the very same witness that has forgotten imported
That's
matter for
correct.
18
It's
times.
the same witness.
All right. If you look at the invoice on Z112, my lord, that will be Z21, Roman letter 4, on page 112.
You are correct.
Yes. This invoice is also quite clear the services for which this invoice was provided. Is that correct?
That's correct.
That is consultation fees for the last 6 months of 2017.
That's correct.
The invoice, at least on the face of it, the invoice does not say that it was for any fishing quota.
You are just correct.
Yes. We can go to the next invoice, Z21-5 on page 113.
And then?
Yes. It also says that it's for additional consultation fees for the last 6 months of 2017.
That's correct.
Yes, and not for fishing quota whatsoever.
That's correct.
Yes. We can also go to page 117.
Yes,
that is another invoice, is that correct?
That's correct.
And the same invoice stipulates for what it was, for what services it was issued. Is that correct?
That's correct.
Being consultancy services for June and September 2018, is that correct?
That's correct.
In the tax invoices, I mean, we can go through each and every one of these invoices, but basically all these invoices are very clear that, I mean, you can even look at page 129 of the record. Z21, I believe it will be Roman letter 17, my lord. These are already exhibits, but it's on page 129 handwritten from Wayamba Investment Trust. Is that correct?
That's correct.
It's also clear that it's for consultancy services.
That's
We can confirm that all those invoices, none of them, I mean, of course, I don't want to waste the cost time because I would like this exercise to end at some stage. If you look at the invoice, page 169, I believe it's 213538, my lord.
169.
Yes, that's exhibit Z21 38. You see that?
Yes, I'm there.
All these invoices, they are very specific for what they were issued for, being vessel repair, maintenance for October 2019, vessel management fees for November 2019 and August 2020, all the way to August 2020. Is that correct?
That's correct.
None of them say that they were issued for fishing quota or usage fees. Is that correct?
Yes, you are just correct.
If you go to page 179, we have already dealt with this earlier. These being the emails from Mr. Canosa.
Yes.
He confirms that, if you look at that email alone, he, having scrutinized the invoices as we have already agreed, he directs that the only thing that needed to be corrected in that is that it must be a tax invoice. Would that be correct?
That's correct.
He never said, why are you charging me for this? He's not.
Sorry, Mr. Patela. I just want to. You said page 1?
Page 179.
Yes.
That would be exhibit Z21. I hope I'm right here, but it must be 45, Roman letter 45.
Z?
44, sorry, my lord. Exhibit Z21, Roman letter 44.
Roman letter 44, yeah?
On page 179.
Yeah.
Yes, my lord.
You are saying?
I was saying this is one of those emails that we dealt with from Mr. Canosa, where the only thing that he requested in respect of some of those, at least one of those emails or some of those emails, was that they must be in a tax invoice. Is that correct, Mr.?
That is correct.
He never complained that there is a breach of agreement by, Fisco or anyone.
No, he never complained it.
To the best of your recollection, there is no arbitration court case that Novanama has referred to you where they have declared a dispute that they have paid.
Not the one I'm aware of.
Yes. And this is a... Yes, my lord, I thought...
No.
Oh, I thought you wanted to,
okay.
to make a direction, my lord.
Okay.
And insofar as we have looked at, this is a company that seems to have at least some, government structures where Mr. Canosa is not the only decision maker. Is that correct? In fact, in his statement, he says when he received, a proposal, he would send it to his, to his bosses for approval. Is that correct?
Yes, that is what he said.
Yes. And he was not working alone as an individual. Is that correct?
That's
he was
correct.
not the only decision maker in this company.
That's correct.
And yet this company that knows his rights, have all these written agreements, have never sued either Fishco, Mr. Ngepunya, or the government of the Republic of Namibia for being forced to unlawfully pay, the amounts that were not due and payable.
Not what I'm aware
During
of.
your investigations. Lord, I would like, if His Lordship can afford me another maybe 5 to 10 minutes adjournment, because I want to move now to another direction of my cross-examination in view of what we discussed in chambers, my Lord.
Court will adjourn for until it's 15:35? 15:45 we start.
As a precision, my Lord.
Court will rise.